Ready? Exercise number 8. Start. The learned magistrate disbelieved the endorsement made by the concerned food inspector on the report Exhibit K3 that no one was ready to be an independent witness on the ground that the endorsement was made in the handwriting of the food inspector who could not be examined due to his death, and as such the accused could not get any opportunity to test the correctness of the endorsement. In view of these reasons, the learned magistrate arrived at the conclusion that there was no compliance of Section 10 subsection 7 of the Act at the time of collection of sample. The opposite party number 1 was therefore entitled to be acquitted. Stop. Next para. Section 10 subsection 7 of the Act provides that where the food inspector takes any action under clause A of subsection 1, subsection 2, subsection 4 or subsection 6, he shall call one or more persons to be present at the time when such action is taken and take his or their signatures. This provision seems to be mandatory in nature. What is contemplated by Section 10 subsection 7 of the said Act is that the food inspector, while taking action for taking sample of any food, must call one or more persons to be present at that time. If the food inspector makes attempt to call one or more persons at the time of taking sample and the persons so called by him shows their unwillingness to be witnesses, the food inspector cannot be blamed in such situation, and it will be deemed that the food inspector has made sufficient compliance of Section 10 subsection 7 of the Act. But where the food inspector does not make any such attempt, it would amount to violation of the mandatory provisions of Section 10 subsection 7 of the Act. Section 10 subsection 7 of the Act seems to have significance due to the reason that the proceedings done by the food inspector may get authenticity during trial and the prosecution version may be believed. In absence of due compliance of the provisions of Section 10 subsection 7 of the Act, a valid conviction cannot be recorded against the accused, especially when the accused denies the factum of taking of sample by the food inspector. Stop. Next para. The learned AGA submitted that the learned magistrate has not considered the case on merit and acquitted the appellant merely on the ground of non-compliance of Section 10 subsection 7 of the Act. The acquittal recorded by the learned magistrate was not proper. In my opinion, the views recorded by the learned magistrate were based on proper appraisal of evidence. If some other view is also possible on reappraisal of evidence, the order of acquittal cannot be set aside. In that event, the appellant court has to approve the views of the trial court and dismiss the appeal. In the case of State of UP versus Punni and others under bracket 2002 bracket out 1 SCC under bracket criminal bracket out 372, the Supreme Court has held that if two views are reasonably possible, the appellate court would not normally interfere with the order of acquittal. Stop. Next para. In view of the peculiar situation of the case, the order of acquittal based on non-compliance of Section 10 subsection 7 of the Act cannot be upset on the lines suggested by the AGA. For the reasons discussed above, the appeal has no merit. It is accordingly dismissed. Full stop. Thank you very much. Guys, there is one humble request. Please always try to repeat the matter. Then only your accuracy and fluency on steno will increase. And also there is one more request. If you found the matter is excellent, you can give your valuable comment on my YouTube channel. And also for next audio, you can subscribe my channel. Thank you very much.